In this segment of our discussion of school law and policy, we're going to look at legal issues in employment, particularly discrimination in employment. And the Equal Protection Clause of the 14th Amendment provides protection against group discrimination, unfair treatment, and is often used as the vehicle for individuals who seek relief from various forms of discrimination. That's the constitutional provision. So constitutional, federal, and state statutes also prohibit discriminating practices in employment on the basis of sex, race, age, color, and religion. Many of the significant pieces of legislation were enacted in the 60s and 70s, the most significant being Title VII of the Civil Rights Act in 1964, which prohibited employment discrimination based on race, color, religion, sex, and national origin. And so the due process provision is really the standard for employment discrimination. The 5th and the 14th Amendment, in this case, to the U.S. Constitution, limit the power of federal and state governments to discriminate. These amendments require that individuals not be deprived of life, liberty, or property without the due process of law. So the due process provision applies to employees as well as students. They also require that individuals receive equal protection under the laws. With respect to employment, equal protection provisions limit the power of the state and the federal government to discriminate in their employment practices, and they're required to treat employees and prospective employees fairly with respect to job applications and employment decisions, irrespective of race, color, gender, national origin, or religion. Title VII, looking a little more detail at Title VII, the U.S. Supreme Court developed a 3-step procedure for Title VII challenges, and these cases are non-educational cases, so we won't go through those, but the steps involved the same procedures for all cases that involve alleged discrimination, including those in public schools. So the 3 steps are as follows. First of all, the plaintiff carries the initial burden of proving employment discrimination. The second step is that once that is levied, the burden shifts to the defendant, in this case would be the school district, to refute this burden of discrimination by demonstrating that a legitimate non-discriminatory purpose forms the basis for its actions. And then the third step is if the defendant is successful in its contention, then the burden shifts back to the plaintiff to show that the defendant's actions were a mere pretext for discrimination. Of course, if the defendant can't demonstrate the absence of a discriminatory motive, then there's no need even to go into step 3. Of these different discriminatory bases, the discrimination based on sex is also included in Title IX of the Education Amendments in 1972, which prohibits sexual discrimination by public and private institutions. And the North Haven Board of Ed v. Bell is one of the early challenges to Title IX, in which two local boards actually argued that Title IX was not meant to affect employment practices in school districts. And the Supreme Court held that Title IX regulations prohibiting sex discrimination must be program specific. As such, they apply to programs that receive federal funds. And that's a little bit of a nuance, but it is very wide because most school programs receive federal funds and they're program wide. The Rehabilitation Act of 1973 and the American Disabilities Act, the ADA, in 1990, are also important pieces of legislation for discriminatory practice in employment law. The ADA, and in conjunction with IDEA, protects individuals against discrimination based on their disability. Section 504, which you're familiar with students, is part of the Rehabilitation Act of 1973, and it also prohibits discrimination against any otherwise qualified person who has a disability with respect to employment, training, compensation, promotion, fringe benefit, and terms and conditions of employment. Under the Act, no otherwise qualified individual with a handicap shall solely by reason of his or her handicap be excluded from participation in, be denied the benefits of, or subjected to discrimination under any program or activity receiving federal funds. So ADA and 504 protect not only students with disabilities, but any person who has a physical or mental impairment that substantially limits one or more major life activities and has a record of such impairments or regarded by others as having that impairment. So they both affect public schools by prohibiting disability-based discrimination. Talk a little bit about racial discrimination. The courts use various standards to address racial discrimination. The Equal Protection Clause of the 14th Amendment is mostly the one that's relied on to eradicate patterns of race discrimination in public schools. The equal protection standards prohibited discrimination that can be linked with racially motivated objectives. Unlike Title VII, no remedial action is attached to the Equal Protection Clause unless there's clear evidence of the existence of official and deliberate law or policies to promote segregation. So this gets into some of the issues we talked about with regard to segregated schools. The Griggs v. Duke Power Company is a non-education case, but it is a case considered one of the most compelling involving race discrimination. Prior to the passage of the Civil Rights Act in 1964, Duke Power had openly discriminated based on race in hiring and assigning employees to its plants. In 1995, the company required employees to possess a high school diploma for initial assignment to any but the lowest paid traditionally Black departments. In order to transfer the higher paying white departments, the employee had to earn satisfactory scores on a professionally prepared general aptitude test. It was revealed that whites who met neither of these requirements had adequately performing jobs in these higher paid departments for years. Black employees challenged the diploma and testing requirements, which rendered a disproportionate number of Blacks ineligible for employment and transfer. The U.S. Supreme Court held for the plaintiffs and ruled that the diploma or degree requirements and generalized aptitude tests may not be used when they effectively disqualify a disproportionate number of minorities unless these tests are proven to be directly correlated to the skills tested and adequate job performance. So that's a pretty significant rendering there. There are several other landmark U.S. Supreme Court cases and Supreme Court rulings that address the legality of race-based admissions in higher ed. And of course, these are still in and under consideration by the U.S. Supreme Court. And of course, this is something that we're going to see for the foreseeable future. Age discrimination is another area in public schools primarily affects teachers. In past years, many districts force teachers to retire when they reach an arbitrarily predetermined age. These policies and practices have been challenged under the equal protection guarantees, many of which receive mixed reviews in the courts. However, all challenges and uncertainties became insignificant with the passage of the Age Discrimination in Employment Act in 1967. And amended in 1968, this act prohibits forced retirement of employees by protecting individuals above the age of 40 from discrimination on age with respect to hiring, dismissal, and other terms and conditions of employment. Interestingly, after the passage of this act, a number of cases still made their way to the courts. And of course, generally, they're are taking a pretty strong view of age-based discrimination. Finally, we want to talk about the Family Medical Leave Act, enacted in 1993. It was designed to provide unpaid leave during any 12-month period for birth and care of children, placement of children with an employee for adoption or foster care, care of a spouse, son, daughter, parent, employee with serious health conditions, a serious condition that the employee has that prevents them from working and fulfilling functions. Upon return from FMLA, an employee may not be demoted, transferred to another position unless transfer is equivalent with respect to pay, status, benefits, and other terms and conditions of employment. And under no circumstance can an employee be penalized for family medical leave. Pregnancy is another issue in school employment that's been controversial over the years. And from the early days of the profession, teachers in public schools are protected by the Pregnancy Discrimination Act. And this law is an amendment to Title VII, which extends protection to pregnant employees against any forms of discrimination based on pregnancy. The courts have been fairly consistent in issues related to pregnancy, Prior to the enactment of the law, it was not uncommon for districts to enforce policy cutoff dates in which females were required to leave their positions due to pregnancy status. Several interesting cases have come out of this. One of the most interesting focuses on the use of sick leave and superintendents preventing women from using sick leave for pregnancy. And in most cases, the courts have been very strongly supportive in upholding the Pregnancy Discrimination Act in favor of the plaintiffs. So we will consider one more employment-related issue, and that's dealing with recruitment, tenure, dismissal, and promotion.